This is Bloomberg Law with June Grasso from Bloomberg Radio.
When listing the winners from this term at the Supreme Court, former President Donald Trump stands at the top of the list. In a historic 6-3 ruling, the court's conservative majority ruled for the first time that former presidents have broad immunity from prosecution. While the court didn't grant Trump the complete and total immunity from prosecution he sought, it conferred enough of a shield to all but ensure that Trump won't be tried for election interference before November. Joining me is Victoria Nourse, a professor at Georgetown Law and an expert on separation of powers. In dissent, Justice Sonia Sotomayor wrote that the president is now a king above the law. Do you think that's what this decision really leads to?
Well, I think there are tremendous risks posed by that opinion because basically the majority opinion allows the president doesn't answer the SEAL Team 6 question. That was Judge Pan who said, what if the president orders SEAL Team 6 to kill his political opponent? The majority does not shut down the fact that that would be an official act and could not be prosecuted. And that is why she's saying that.
Can you explain broadly what the opinion does?
The opinion complicates the trial by injecting this question of official act immunity. So most lawyers thought that the two main precedents here were the Nixon case and the Clinton case, all right? Two presidents. One was sued civilly, one was in the criminal thing. And in both those cases, they start out and say very emphatically the president is not above the law, okay? He can be subpoenaed and to be in a criminal trial, and he has to suffer, civil justice for what he did. But the court went off on a different case called Harlow, which is a civil case and involving President Nixon. And that says that you can't sue a president civilly for damages for, an executive order. And everyone thinks that's right. So he issues an executive order and it somehow hurts someone or changes their job in the military. You can't sue him for that, because that would just tie up government. Everyone agrees that's the law. But what they did is they took that Harlow thing and said that applies to criminal cases. And now Judge Chutkan will have to hold a hearing about what of the acts in the indictment are official and what aren't. And some of the statements in the majority opinion seem to say that conversations with other officials, like the Attorney General, are absolutely immune. But then what happens if you're having a conversation with SEAL Team 6 or the head of the Defense Department? Is that official and you can never indict someone if they've done something terrible? So it looks like it doesn't answer that hypothetical. And it's particularly dangerous if you have a president like Trump who is always pushing the envelope. So if he orders the Defense Department to shoot protesters, right, he could say that's official. That's what people are very worried about.
These 6 are supposedly originalists. Is there anything in the Constitution or history that supports this decision?
There's certainly nothing in the text. The text says that Congress, the founders wanted Congress to be the important body here. That's why it's in Article 1. The Supreme Court was in the basement of the Senate for most of the 19th century. And it's in Article 3, not Article 1. So the text tells you what's the most important, and they have immunity for things they say because the king in Britain used to, throw the members of parliament and the members of commons in jail. So no one wanted that to happen. But there is no text on immunity. Now, the historical case, which they decided, there's another case called Dance that was decided in the last few years, which is about whether Trump could be subpoenaed in this Mazars accounting firm case. And they said yes, because they relied on the Burr case. And they'd held that in the Nixon case, too. And so everyone thought, well, if you can subpoena him, if he can be an unindicted co-conspirator, as in Nixon, then of course, if he's a former president, he can be subject to criminal sanction. Is there anything in history to know? This has never happened before.
So how did they come up with this? Where did they get
from
this
their own precedent? So basically, they took this case called Harlow, which was a guy who sued Nixon because of what Nixon did to him. Nixon had some, sort of aggressive policing of the executive branch and individuals, and he treated this person terribly. And so the person sued. And the court said, well, yes, he treated you poorly, but if anyone could sue the president for damages, then it would stop government, right? And that's true throughout the government today. You can't sue the Justice Department because you don't like them or with their policies. that's just a general, there are many different doctrines of government estoppel, immunity that apply throughout the government. Like you can't easily sue the government, and particularly for policies you don't like. So that's about money damages, but this is about a crime. So there's a big move there. And so basically Roberts made this all up. Talk about making up legislating. I mean, I find it very odd because it also is not very clear about how you're actually going to do this. Now, the truth is that if people are worried about this, they shouldn't be too worried. You know, they shouldn't be worried about the rule of law because they decide 40 cases a year that no one cares about and are just, whether it's original or not, you know, it's within the realm of reason, in my view. This term, however, they decided about 6 cases that are going to scare the American public. And they show no interest in actually being statesmen or calming the waters, which is disturbing to me as someone who studies the whole Constitution. But they relied on precedent. I told you that civil case, and then they applied it to a criminal case. But all their application of the doctrine, so they've got this official immunity once they adopt it from the Harlow case, and they apply that to criminal cases, which is a leap there, number one. But then the majority opinion is this long discussion about the difference between allegations in the indictment about what was official and what was not. So they say it was official if you talk to your attorney general. Well, what if you talk to your attorney general to bribe someone? I mean, that was all the discussion in the oral argument and why Southern Europe pushed back. So there are 3 buckets that they develop, and there's nothing in the text of the Constitution that says any of this. So one is the absolute immunity. So some conversation referred to with Bill Barr is out. Then the question is about Mike Pence, and that's in this middle ground that they've given presumptive immunity to, but it can be rebutted. And then there's the stuff that, you know, probably private. And this is where Justice Barrett did the country a great service by noting, as the D.C. Circuit had held, that the fake elector scam was all private. Even the speech, in my view, was private because it was funded by the campaign, because if they spent federal dollars on that, that would be a felony. You can't spend federal money on a campaign speech. So there are 3 buckets. We're going to have a big hearing about it. Everyone's going to scratch their heads about this, and the court is going to look terrible. You know, I've spent my whole life defending the rule of law, and I'm really sad, and I'm kind of angry at Roberts for doing this because I just think it showed so little sense of where the country is. They decided a case they didn't need to decide, which is imprudent. They could have written it very simply. It was really complicated. So, you know, usually like Brown versus Ford, it's a very short Delphic thing with 9 people on it, right? It's hubris. It's just hubris and lack of statesmanship and understanding they're a part of the Constitution. They're not above it. They are not. They are part of it. And so that hubris is a real problem. And I think the American people, their only option now is to make the court a political issue. So there are things Congress can do. They can reverse Loper Bright. They can reverse a lot of these things. So people are going to have to elect people who will actually do that kind of stuff if they want it to change, because there's no way the court will be packed. FDR had 67 votes.
When Trump lost the 2020 election, the Supreme Court basically turned away his different challenges. What do you think happened at the court to lead to this opinion, which paves the way for him to run in November without facing a trial for criminal interference in the 2020 election?
It's their blindness to their role within the Constitution. And, you know, Scalia liked this theory called the unitary executive. That's behind this decision. They all believe they wear bracelets. It's not what would Jesus do. It's what would Anthony Scalia do. They look at the bracelet, and Scalia's most famous opinion was a dissent in Morrison versus Olson against the special counsel. You saw that in Thomas's opinion. He thinks Jack Smith is unconstitutional, and that's being argued down in Eileen Cannon's case. So that gives the president a lot of power. That's part of the tenet of originalism. There's no textual source of this. They've used something called the vesting clause, which was added at the end of the Constitutional Convention. It's sort of like a header. But anyway, it says, shall vest the executive power in a president. They view that as, to quote a professor's book, imperial from the beginning. And they've been saying this for years out loud. Now, I've written extensively about why they're adding text to the Constitution effectively, because for some time, Justice Scalia wrote in that opinion that the president has all executive power, and the word all is not in there. And the fact that they're arguing that, I mean, the greatest generation will be rolling over in their grave. Robert Jackson, who wrote in opinion called steel seizure, that when the government argued that, the Nixon thing, if I do it, it's legal, that it was the kind of language for a totalitarian. And this is what I have taught for years. I push back on the unitary executive. And so this is a theory that some moderates in the Republican Party adopt, like the George W. Bush persons. Now, note, there is something important to note. There were a lot of fancy conservative lawyers telling them not to do this, and yet they did, like Charles Cooper, Peter Keisler, that very clause you're citing, that text. So they focus on the executive vesting clause. But right after the executive vesting clause, the president must faithfully execute the law. And so these conservatives argued, well, the president can't violate the law. He has to faithfully execute the law. And there's nothing in the vesting clause. It's just as sort of a header or a description that undermines the president's duty. And they did not accept that argument. So my head has been exploding since I heard the oral argument, because I know that behind this is the assumption that the unitary executive is a wise thing. So what they've done is they've aggrandized the president and they've aggrandized themselves. And what can I say, except for historically we've had other legal revolutions. So this isn't just constitutional because of Loper-Bright and all the statutory stuff. I study textualism. It's a theory for easy cases, not hard cases, for the president being 35, but it's not about, the limits of executive power. And so I think that they've begun the seeds of destruction of originalism, because there's nothing historically that really supports what they've done. There's nothing in the text that supports what they've done. And so we now see that this originalism, 1787 stuff is a veneer. So yeah, women, okay, you go back to the witch hunter in 13th century. But meanwhile, the president can do anything he wants. It's not well thought out. It's more political in the sense of, I don't like that word. There's a philosopher who calls it the cunning of unreason in politics. And this was a unitary executive opinion, because they think they're looking down at their what would Justice Scalia do bracelet. And they're really, really not thinking of that, particularly in the era of Trump. So this is extremely dangerous for what will come if Trump wins the election.
So they're all for this unitary executive, a strong president, yet they're against the administrative state, and they took away power from federal agencies. The president is controlling. How do you reconcile those two?
Well, they want the president, not the executive branch. They think the president, under unitary executive, has to be in charge of all. There has to be one line from the president to every person in the administration. So they want to politicize the executive, actually, and they want to get rid of expertise. That's the twin punch. It's like Trump with his Schedule F. He wants to get rid of, the scientists and the notion of expertise. It's also a power move for them. So they, in their statutory interpretation world, they say what the law is. It comes from Marbury versus Madison. It comes from the most vacuous statement there, because if you ask the president, any president, do you say what the law is? They say, yeah, I sign the laws. So does Congress. It doesn't mean anything. All it says is that we get to decide. So they've tied the administrative state up into knots by saying, if you haven't written it quite correctly, we get to say no. So they've given themselves a lot of power, mostly with the Loper-Bright thing, in my view. And Republicans don't care to actually affirmatively regulate. They only believe in deregulation. So it's a one-way ratchet. If Trump deregulates, it's not clear they will think that's a major question. There's nothing to review.
Trump is asking the judge in the hush money trial, where he was convicted, for things that happened before he was president. So tell us what Trump's argument is.
Okay, so Hope Hicks testified, and she corroborated the testimony of Michael Cohen. And that she was an official. She worked for Trump. And in this opinion, it says conversations with the Attorney General, Bill Barr, are absolutely immune. And federal constitutional law governs, any criminal trial. So the question is whether he's going to say, okay, I think they would have held the same verdict, even if we get rid of that testimony. It was harmless error. If the judge does that, I'm sure there will be 6 zillion appeals. I think they thought that the danger here is criminalizing politics. And the right keeps telling me, oh, this means Trump can't vindictively prosecute Biden. And that's just false, because you can still prosecute people for personal acts, right? So this was a personal act in the New York case. So what, he paid off the porn star before he was president. That was personal. He used a personal lawyer. He wasn't president, so you can't say that. But there was testimony in the case by one of his aides about the payments when he was in the White House. So basically, two district court judges, the guy in New York and Judge Chutkin, their heads must be spinning because they have to decipher all this stuff. And it's not clear what they should do. My own view is this is one of those cases where they should think of the country, because this is just going back to the court. It's like the abortion. Like, they decided the abortion thing thinking it would go away. And anyone who knows anything about the abortion stuff and the different state laws says, that's kind of crazy. That's going back. Guns. And so I just wrote an op-ed in the Republic about, this is just chaos right now. I defend the different realms of politics and law. And law should move slow. This is why progressives don't like me, because I'm like, no, there's some virtue to moving slow. Even Brown, there was virtue in them getting to the point where it was ridiculous, where the guy was sitting outside the classroom, and the black guy had to sit 2 inches away from the classroom. I mean, the cases had made it, important for the court at that point in real life to make a general pronouncement. But this court has not moved slowly, and its philosophy really isn't coherent. So they're taking a modern notion of right that no historian thinks existed in 1787. So it's really a problem. And one of the reasons it's a problem is that FedSoc is the only source of information. It's a feedback loop over there. So I've appeared there maybe 20 times on statutory interpretation of the separation of powers, because I'm one of the few women who do the separation of powers. Because the last time I went there, and I was talking about the Federalist Papers, I have a theory about them, and it's kind of interesting, I think. And, I give a good speech. And I made an aside about President Biden, who thought I was a nutcase because I had the Federalist Papers on my lap reading them because I wanted to be an academic, and he thought that was very weird for a feminist. And they booed him. When I said Biden, they booed. That's not a legal society. That's some kind of political campaign to me. So, it's not a happy look for those of us who care about the rule of law. The good news is there is a new conservative society called the Rule of Law Society, like Peter Kaiser, all those people I mentioned who wrote that brief in the case that told them not to do this. So there is an alternative now for students and people who think they're conservative. I won't join it because they say they're conservative. I don't think that's the rule of law. The rule of law is not conservative or liberal. The rule of law is about consistency. It's about certain kinds of reasons. So politicians, they just say stuff. They don't necessarily have to have good reasons, right? Judges have to have reasons that make sense to lots of other lawyers, not to be treated with derision. So that's why I'm sad for the court, because the American public's just not going to understand this. And it's going to breed a lot of cynicism in our system just at the time we need faith in the rule of law. It's a work in progress. We often fail. We fail all the time. But this was a massive fail.
The implications of this decision will reverberate and keep reverberating. Thanks so much for joining me, Victoria. That's Professor Victoria Nourse of Georgetown Law.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.